This is an appeal in the matter of Secretary of State for the Home Department and the First-tier Tribunal, Asylum Support.
Yes, Mr. Biggs.
Yes, good morning, my lords. So, as you know, I appear on behalf of the appellant Secretary of State for the Home Department. My learned friend, Ms. Irina Savic, KC, together with Mr. Alex Grigg, appear on behalf of MAH, one of the interveners. One of the interested parties, forgive me. There's also an intervention by ASAP by way of written submissions, and I think counsel for ASAP are in court. The respondent tribunal, as is the usual practice, is not represented and has taken a neutral position in these proceedings to date. My lords, I should deal with a couple of housekeeping matters in respect of bundles to begin with. The electronic bundle was updated on Friday evening, so I'd be grateful, my lords, if you could confirm that you have the updated bundle. The only difference is that an additional authority was added at the end of the bundle that the interveners would like you to look at. A case called Stock and Frank Jones. So that should now be item 54 of the index, page 1272. I don't think that will have reached the hard copies, and so I have hard copies to insert.
Yes, please.
So for those of you using the hard copies,
permission's given in May, and it's in a separate supplementary bundle. Thank you so much. It's in supplementary bundle for the intervener.
I don't have the supplementary bundle for the intervener, I'm afraid. And Lord Justice Peter Jackson tells me it's a separate bundle altogether.
yes, I'll just need to double check when that came in. I think it was last week.
Right.
There is if you like, additional separate supplementary bundle that contains material in respect of the intervention. We understand that had been filed last week, as I say. If there's a problem with that, I'm sure we can arrange for copies to be provided. I'm great.
I've got it. It's got 4 tabs.
Yes, that's right, my lord. So there should be an electronic version and a hard copy version. I'm not sure why my lord, Lord Justice Bean does not have it, but we can try and remedy that.
Can I ask my colleague's judicial assistant to go and see my clerk and ask what's happened to the intervener's bundle? Right, Mr. Biggs, carry on.
Thank you, my lord. Just a couple of further housekeeping matters. So there's also a supplementary authorities bundle that contains just 3 items. That will have
As
been
though 54 were not enough.
Well, I appreciate we have included quite a lot of material for the court. We think it's all helpful, obviously, but I appreciate there's quite a lot of material. Adding to that, though, there are these 3 additional authorities contained within the supplementary authorities bundle. It was, I understand, uploaded an email this morning, but you won't have, I don't think, seen it. We have hard copies, and perhaps if I can hand those up now.
Yes, please.
Having had the advantage of the intervener's bundle, I can't get all right.
All right, Mr. Biggs,
The
thank you.
final housekeeping matter is a very small matter. We filed a replacement skeleton argument, and on reviewing the case, we realised that paragraph 66 of the skeleton argument was perhaps not as clear as it could be. And so we filed this morning a very slightly amended version of our skeleton argument that hopefully clarifies paragraph 66. There's no objection by MAH to that going in. That was filed electronically, and I have hard copies if the court wants to look at the hard copies, but I don't think it's something that we need to look at during the course of the hearing. But if the court wants to look at wants a hard copy, we have
Not
it.
particularly. If there's something which is there which is actually wrong or has been changed, perhaps you get it. This is in your skeleton.
It is, my lord.
Just tell us what the
Yes, so there's just an unfortunate typo in line 3. The word not shouldn't be there, it should be absent.
all right.
And we've added some additional text to the first sentence just to make it clear that we don't say that on Mr. Justice Chamberlain's analysis, the AST would only have jurisdiction to allow an appeal in all cases. What we say is that on Mr. Justice Chamberlain's analysis, the First-tier Tribunal would only have jurisdiction to allow a Section 103(2) appeal, only where the issue is whether a decision deeming an asylum claim withdrawn is valid, only where that's the issue between the parties. And so we thought it would be helpful just to make that express rather than implicit.
Is that paragraph 66?
It is, my lord, yes.
Can I ask you about paragraph 37?
Sorry, before we leave 66,
Yes.
you eliminated a not a moment ago. Which not?
It's in the version I'm looking at, it's 3 lines down, second sentence, just before the word stop.
Yes, well, that happens to be on the second line. That's why I was.
Right, very well.
Right,
Obviously,
I'll
I'm
take
looking at the slightly amended version, so the line.
Thank you.
Yes, my lord, you would ask, I think, about paragraph 37.
Paragraph 37.
Yes.
Says this provision also indicates that tribunal hearing a section 133 appeal does have jurisdiction. Should that be a not?
Indeed, it should.
Has the not gone flying from 66 to 37?
I would be grateful if you could replace the not from that paragraph into paragraph 37. Thank you very much, my lord. I'm very grateful.
Can I just check? Is anybody else trying to get online and having difficulty to get online, either with Gov Wi-Fi?
It's not something that I've been trying to do or can do, but I can turn my back and see if there are
You
problems.
dinosaurs sometimes
Yeah. Can I
have
ask?
an advantage.
You're online. What, with Gov or judicial? Judicial.
My lord, if I may, I'm trying to connect on Gov and I'm equally having difficulties.
Okay.
Judicial is the only one reliable.
Thank you.
Well, I don't know, my lord, whether that's something that
Don't worry,
that
I
will
can
hold us
survive
up.
without it.
I'm grateful.
I can survive that Wi-Fi for a whole morning.
Thank you.
I'm on GovWK.
Okay. Well, I'm told my instructing solicitor isn't having the difficulties that my lord is having. I'm not sure. I think that's probably small comfort, but
Oh dear.
Person.
Well, if you bear in mind, Mr. Biggs, that some of us, I at any rate, will be following you in hard copy.
yes.
Others on screen, others may be on screen, but it's not connected. But I'm sure you'll manage.
Thank you very much, my lord. So, my lords, I will jump straight in then to my submissions after having dealt with those housekeeping matters. So there are 2 issues for the court. The first I will call the collateral challenge jurisdiction issue, which is the question as to whether the Asylum Support Tribunal, the First-tier Tribunal, under a Section 103 appeal, has jurisdiction to consider the merits or the validity of a decision deeming an asylum claim withdrawn that is separate from and precedes the decision that is appealed. The second issue concerns the proviso in section 103(2) of the Immigration and Asylum Act 1999, which limits the scope of that appeal to cases where support is discontinued in circumstances where the support would not otherwise have been discontinued. We agree with the judge below that the central and prime issue is the first issue, but the second issue is also important and raises some distinct questions.
Mr. Biggs, before you dive into the first issue, can you help me by going to Mr. Justice Chamberlain's judgment? He asks, he says that there are 6 questions to be answered.
Yes, so that's page 76 for the judgment in the core bundle.
Yes. Now,
The 6 questions are at paragraph 81, my lord.
Yes.
Page 96.
I was going to ask, has he asked the right questions before we come to the answers?
Yes. They're not the questions that that we would have asked. We respectfully submit that it's unnecessary to break down the 2 issues that I've identified into those, I think 5 actually, questions at paragraph
5.
81. The key question in respect of issue 1 is actually question D. And we respectfully do not suggest that the answer to that question can helpfully be explored by going through the first 4 questions first. Better, in our respectful submission, to grapple with the point of principle raised by question D and then go on to the second key question, which is the 5th question asked at paragraph 81. There is a danger in this case of circularity and, well, not necessarily circularity, but the structure of analysis can have a bearing on the outcome. So we would respectfully suggest that the appropriate approach is to focus on the last 2 questions of paragraph 81.
C, D, and E.
Yes, D and E, and C, insofar as it bears on D, is relevant, but we never argued below, with great respect to Mr. Chamberlain, and we don't argue before my lords, that there is a presumption or general rule barring collateral challenges. Our position has always been that whether or not a collateral challenge jurisdiction exists depends on the construction of the statutory scheme conferring jurisdiction on a statutory tribunal. There are no presumptions or rules. There are principles of interpretation that have a bearing, but everything depends on the construction of the particular statutory scheme.
All right, but let's suppose that we look at Mr. Justice Chamberlain's questions under 81. Do you have an answer to A and B?
Yes, so the answer to A is that leaving aside the collateral challenge issue, which is a distinct issue we submit. You will have picked that up, my lords, from our skeleton argument.
Yeah.
The First-tier Tribunal does have jurisdiction to consider whether a person is an asylum seeker for the purposes of the definition in Section 94 and therefore for the purposes of an entitlement to support under Section 95. That was decided in a case called MAH.
Is that Judge Gilbart's case?
That's right. And we have never suggested that that is incorrect.
Yeah.
Our submission is that that does not inform the ultimate outcome in the instant case, because that depends in respect of issue 1 on whether there is a collateral challenge jurisdiction, which is a distinct question. The answer to issue B is, we respectfully submit, the answer given by Mr. Justice Chamberlain at paragraph 90.
Yeah.
So we accept that that aspect of the learned judge's judgment is correct. So that's at the top of page 98. So that conclusion does inform the collateral challenge, the resolution of the collateral challenge issue, because we submit that the implication of the fact that a separate decision under the Immigration Act 1971 means that someone is not an asylum seeker is that support under the statutory scheme has to end and the person not eligible for that support. And so unless that separate decision can be challenged by way of a collateral attack, the question of eligibility for support under Section 95 can only be answered against a putative appellant. But there is no issue as to the correctness of paragraph 90.
So the answer to B is no. If you imagine an express withdrawal, as it were, dear Home Secretary, I hereby withdraw my claim, that person is no longer an asylum seeker for the purposes of Section 94(1).
Yes, the answer is no. I just wanted to go back to how the question was formulated to make it. Yeah.
Could I just clarify? You mentioned two issues,
Yes, Lord.
and you identified them both as important, but one as more important,
One is more central.
more central. And are they in fact grounds 2 and 1 in that order? Is that what how it's coming out? Is the collateral challenge issue to be described as ground 2 and the 103(2) to be described as ground 1, or is that not it?
Well, I'm sorry, my lord. I'm just going back to the grounds of appeal, which are on page 53. I think actually ground 1 reflects what I called issue 1. And ground 2 reflects what I called issue 2.
I see. All right. Sorry to cause confusion.
No, not at all. I just wanted to, I mean, we have, I mean, as I've indicated, the structure of looking at those issues might be significant because it could potentially lead one to a potentially incorrect conclusion. At this stage, we accept that the prime or central issue is in respect of collateral challenge, and that reflects ground 1. So, my lords, unless there are any other observations.
Is Mr. Justice Chamberlain's 81D and E, has he got ground 2 and ground 1 the wrong way round?
No, because I think I need to double. I think when we were below, we had put these points in the other order,
Never mind.
which is why my lord's question was
the question: can the tribunal inquire into the validity of decision to treat asylum claim as withdrawn?
Yes,
is the central question.
Yes, in my respect, both questions are important. That's central to the analysis overall. So, dealing then with the central issue, the starting point in my submission must be the text of Section 103, situated in its proper context, but the text of Section 103 Section 103 of the 99 Act is on page 38 behind tab 3 of the authorities bundle. And the structure of this provision is as follows. Subsections 1, 2 and 2A confer rights of appeal in respect of particular decisions in particular circumstances. Sub 1 has been called a qualification appeal because it's concerned with whether a person qualifies to Section 95 support on an application for that support. Sub 2 is concerned with what has been called a stoppage appeal or a discontinuation appeal. And just pausing here, the important difference in formulation between sub 1 and 2 that's relevant to issue 2 is apparent from the words immediately after section 95 in sub 2. The words before that support would otherwise have come to an end. And the meaning and effect of those words is central to issue 2. Subparagraph.
Sorry.
Sorry, my lord.
We'll probably come to this. Is it those words that you rely upon for the distinction that you draw between 103.1, where you've made a concession that there is jurisdiction, and 103.2, where you say there isn't?
Yes.
Okay. Well, you're speaking entirely for myself. You're going to have to explain that.
Well, let me just be clear about that. In respect of both a section 103.1 appeal and a section 103.2 appeal, and indeed a section 103.2a appeal, which I hadn't come to, we say that there's no collateral challenge jurisdiction.
No collateral challenge.
No. So on issue 1, the outcome is the same, irrespective of whether you have an appeal under sub 1, 2, or 2a. So if my lord's question was suggesting that in respect of issue 1, that our position is that there's some distinction in terms of collateral challenge as between those rights of appeal, that's not our case. Where the language in sub 2 is relevant is in respect of issue 2, because we say that the words before that support would otherwise have come to an end have to have a meaning, and what they mean, as was explained by this court in a case called Dogan, which we'll get to a little later on, is that where a person is, amongst other things, where a person is not an asylum seeker for the purposes of the definition in section 94, they're not entitled to or eligible for support under section 95, and so that support must end under the statutory scheme irrespective of any administrative decision that notifies the person of that reality.
Sorry,
Can you
say that again.
Yes.
Yes.
So we say that the correct understanding of the words before that support would otherwise have come to an end is apparent when one considers the Dogan judgment in this court. And amongst other things, what Dogan explained is that where a person, a support recipient, is no longer an asylum seeker for the purposes of section 94, so that they are no longer entitled to or eligible for support under section 95, the support that they are receiving must end under the statutory scheme, irrespective of any notification to that person of that reality. And so, to use the terminology that's been used in the cases, in that situation, you're not dealing with a stoppage of support, properly understood. you're dealing with a situation where the support has to end under the statutory scheme, irrespective of the notification to that person, the person receiving the support, that the support has to end under the statutory scheme. So in other words, in that situation, the support would have come to an end.
And that's dependent in this, to use the facts of one of these cases, upon a determination which has been accepted to be unlawful.
Yes. So I'm just trying to be absolutely clear and fair. We've not challenged the Asylum Support Tribunal's rulings on the correctness or perhaps legality of the withdrawal decisions, and those decisions have been themselves withdrawn. So yeah, my lord is right. That is the implication of our position.
We need to be completely clear about this. You're saying that the consequence of your submission is that even if someone comes with absolute cast-iron demonstrable proof, for example, that you haven't followed your policy, or you didn't send it to the right letter address, or you sent it to Timbuktu, then the person has still forfeited or lost any right to support, full stop, and cannot do anything about it.
Not quite right, with great respect, my lord, because that person would have a would have the means of challenging that decision by way, for example, of judicial review.
Well, anything else?
Well, no, it would be. I mean, our position is that there's no collateral challenge jurisdiction, so it would be judicial review in that situation. But my lord, I think there's another point to make.
Well, before you leave that one,
yeah.
What is the sense of that? The only way you can challenge a decision, however persuasive proof you may have that the decision was wrong, is by going to the High Court in a jurisdiction which, other than very exceptionally, doesn't try questions of fact.
Well, I mean, in terms of legal process, it would be judicial review. The Secretary of State, though, would plainly be open to receiving representations as to whether to withdraw a decision that's plainly wrong. There is that practical remedy, if you like. To grasp the nestle that my lord puts in front.
What we're asking you about, and forgive us because we think, I want to speak entirely for myself, I think this is absolutely central to the interpretation of the statutes and so on, is what is an asylum seeker supposed to do at the various stages? And I mean, we can look later, if you like, at the letters sent to MAH.
Yes.
None of them, with the exception of giving him 10 days to demonstrate that it was beyond his control, gives an indication of any means of challenging the decision that's been made that he's no longer an asylum seeker. And that seems, to me at any rate, to be a very, very strange state of affairs.
Very well. I think there are 2 points just to flag at this stage. Obviously, I'm going to come to the arguments of principle and the statutory scheme. The first is that if we are right on the construction of the statutory scheme, then what that means is that Parliament has not conferred a right of appeal in these circumstances. Maybe Parliament should have, maybe Parliament will do that in the future. But if there is not a right of appeal, then that is the reality of the legal scheme. And we say there's very good reason to conclude that whatever one may think about the desirability of the situation, that is the reality under the statutory scheme. The other point to make at this stage is that there's nothing particularly special about the fact that a decision withdrawing an asylum claim is only susceptible to judicial review by way of challenge. Other decisions are in the same category, most obviously a paragraph 353 fresh claim decision, which has very similar implications in terms of preventing someone from being eligible for support pursuant to sections 94 and 95. And in due course, I'll take the court through the case law that makes it very clear that in respect of a paragraph 353 fresh claim decision, the First-tier Tribunal in a section 103 appeal does not have jurisdiction, and the only appropriate remedy is judicial review. Another point to make here is that the same outcome would arise in respect of a decision on the merits of an asylum claim, except that those decisions are currently appealable. We say actually nothing should really turn on the fact that currently there's an alternative appeal, because it's at least conceptually possible that that right of appeal could be taken away.
But it, as Justice Chamberlain says, it goes to a different tribunal.
That's right. I mean, that is a practically very important feature of the statutory scheme. And it may not be my strongest point, but we do submit that the conceptual possibility that a right of appeal might be taken away means that it's not appropriate to interpret the scope of the Section 103 appeal by reference to the contingent position that there is a right of appeal in respect of a decision on the merits of an asylum claim. Because we're looking at Parliament's intention at the date that Section 103 was enacted. But as I say, that's perhaps not my strongest point. But the point about paragraph 353 does run, my Lord, with respect to my Lord's observations, the opposite direction to the point my Lord.
And am I right in understanding this, that the fresh claim is not, he doesn't become an asylum seeker again unless and until it's recorded or acknowledged?
Yes, so under the statutory scheme that's been worked out in various cases, most recently a case called Robinson in the Supreme Court that we'll come to very briefly, the Secretary of State has the authority under the statutory scheme to frank or determine whether there is a fresh claim. And that's so even though rights of appeal to the First-tier Tribunal under Part 5 of the Nationality, Immigration and Asylum Act 2002 depend on whether a claim has been made. And from a practical point of view, in answer to my Lord's observation, a 353 decision can have very serious consequences for a person, just as a decision to withdraw an asylum claim can do. And in fact, paragraph 353 is available not only in respect of a situation where an asylum claim has been refused, but also where a asylum claim has been deemed withdrawn pursuant to paragraph 333C of the immigration rules, which is the relevant rule in respect of withdrawals. So I think that's what I can say at this stage, my Lord, but I'm going to come through the statutory scheme and try and persuade my Lord that if there is an unhelpful outcome, that's a necessary outcome in the circumstances, if that makes sense.
I'm sorry that you're getting a lot of questions, but could you just tell us a bit more about the Asylum Support Tribunal? It's a branch of the First-tier Tribunal system. Does it have a substantial workload? How many judges sit in it?
The number of judges, I'm not sure. Substantial workload, it is substantial. We can try and provide some data if that will help.
No, I just want, I mean, it isn't just a small niche operation. And from your perspective, what is it there to do? What questions is it allowed to decide?
Well, it decides. So, what it is there to do is to look at the merits of appealable decisions.
That's quite theoretical. Could you help us if
Yes, of course it is. But
what are the what does the Secretary of State consider the Asylum Support Tribunal is there to do?
So what the Asylum Support Tribunal will do in let's say a Section 103(1) appeal, because its function obviously differs as between the three types of appeal, is it can look at whether someone is in fact qualified for support.
So what are the qualifications for support that it can look at?
So the question as to whether someone is destitute for the purposes of the statute.
Yes.
And specific issues in respect of the relevant regulations. I'm just looking to see whether we have those and I can refer you to them.
Well, really, in plain language, apart from the financial circumstances of the applicant,
yes,
what other typical questions are decided and in your submission can perfectly well be decided by this tribunal?
well, we know from MAH that the tribunal is entitled to look at the definitions in section 94. So if we turn to page 25.
You're retreating into regulation all the time. Could you just say, I understand that I can go to the tribunal if I say I'm destitute, but you've said I'm not.
Yes.
Right. What other problem might I have with your decision that I can take to this tribunal as an example or as an explanation?
Well, I mean, I think that would be the key thing.
Well, I'm thinking, before I asked you the question,
Very well.
that on your case, that's all it's there for. Is to do the sums, if you're right, and that's the limit of this apparatus that Parliament has set up. Right. I want to move on to something else, if I may.
I mean, I may be able to come up with a.
Well, Mr. Biggs, you probably know more than anybody at the bar about this.
There's some head shaking going on behind you. I think you should know.
Well, I'll turn if I may. I
Yes.
that may be
Apparently
my
acceptance
instructions list has
of
already.
destitution.
Sorry, James.
Not from
Oh,
him.
well, head shaking that may not be very helpful for me. I don't know.
Okay.
Forgive me.
Well,
I'm quite interested in this as well. I mean, to give the tribunal jurisdiction, the appellant must show, first of all, I'm an asylum seeker within the statutory definition. I have made a claim which for asylum support, which has been recorded by the Home Office. That's the threshold to get in.
Yes.
And presumably the tribunal can decide that.
Yeah, indeed, I accept that.
But then the other part of the definition of made a claim which has not been withdrawn. You say the tribunal can't decide whether the claim is deemed to have been withdrawn.
No, we accepted below and we maintain this concession that the tribunal can decide as a matter of fact and reality whether there is a decision deeming an asylum claim to be withdrawn. Where we say the jurisdiction under a section 103 appeal ends in terms of collateral challenge regarding withdrawal decisions, deemed withdrawals, is that the tribunal cannot itself decide the merits of a decision by the Secretary of State deeming an asylum claim withdrawn.
So you can decide whether there's a decision deeming the claim withdrawn, but even if it's apparent on the face of it that it's an unlawful decision, the tribunal can't do anything about it.
Well, with great respect, that's obviously a loaded question, but
It is
that is
deliberately
that.
a loaded
I
question. Most of my
appreciate that.
questions
my
are
lord.
extremely fair, but that one is deliberately loaded.
I think the answer on our analysis would have to be yes. The tribunal cannot go behind that.
But why can you investigate the question of whether a person is destitute and not the question of whether the Secretary of State's acted unlawfully?
But because of the limits of the tribunal's jurisdiction in respect of collateral challenge, and the basis of our argument is that the principle of regularity or finality means that the Secretary of State's decision under a separate statutory scheme, the Immigration Act 1971, that an asylum claim has been withdrawn, has to be treated as binding and valid by the First-tier Tribunal unless there's something in the statutory scheme that justifies the conclusion that the jurisdiction under the statutory scheme extends to a collateral challenge.
Once you, sorry to interrupt, have you finished that sentence?
That's the
Before I
point.
overspeak you again.
No, not at all. Go ahead.
Once you accept that the words of section 103, 1 and 2 do not preclude looking at the merits of a decision about destitution,
Yes.
what is there in section 103, 1 or 2 that does preclude you looking at the merits of the decision that the claim has been withdrawn.
Well,
The words are the same.
I'll come. I have a number of points to make as to why, bearing in mind interpretive principles, the text and context and purpose of the scheme, that is the conclusion that you're drawn to. But with great respect, I just take issue with the suggestion, which I think Mr. Justice Chamberlain relied upon, that because you can challenge the or the tribunal can look at the question as to whether someone is eligible for support in respect of the decision that is under appeal, that, if you like, leads to a presumption or inference that you should be able to review the merits or legality of a separate decision to the decision under appeal.
So really, this appeal is all about collateral.
Well, that's why I've called issue 1 the central issue, my lord. Yes.
Can I just finish what I was trying to understand? That you accept that destitution can be investigated, and you accepted, as I understood it, the tribunal can determine whether there has been a decision,
Yes.
that an application has been withdrawn, but you do not accept that it can investigate whether that decision was correct.
Yes.
Right. What is the substance of a decision about whether there has been a decision? It seems to be an empty concept. I mean, obviously there's been a decision, because otherwise people wouldn't be coming and complaining. There's been a decision.
No, well, I accept that this may well have very limited practical value.
Well, I'm not sure. You say very limited practical value. I'm struggling to think of a situation in which the question of whether the Secretary of State had decided something would even arise.
Well, I'll give a general answer, then a specific example, if I may. It is entirely possible that, and this happens, that the Secretary, the decision maker responsible for the decision under appeal, is erroneously of the view that the asylum claim has been withdrawn, perhaps because the records that they're looking at are wrong. If that's the case, then it will be open to an appellant to say there was never any withdrawal decision.
But why would they go to the tribunal? They would say to the Secretary of State, "Where's my money?" The Secretary of State would look into it and say, "Oh, there's a data error."
One would certainly hope so, but sometimes what one
is there as a separate question any right of reconsideration of these decisions?
There are policies that cover that ground. I hesitate to use the word right. I'll double check, but there's certainly the possibility, pursuant to policies, to invite the Secretary of State to reconsider a withdrawal.
That right is not, as I understand it, contained in any of the communications that would be received by a person who was deemed to have been.
In this case, there's no mention of the right to.
And as you say, you don't accept it's a right necessarily.
Well, there are policies that have public law implications, and the Secretary of State will be open to looking at whether a decision to withdraw is one that can be reviewed or maintained. To go back to the concrete example I mentioned, I will give my lord. One possibility that comes to mind is that the Secretary of State's records indicate that a decision to deem an asylum claim withdrawn has been taken, but in fact it was never notified to the person affected. Now, in that situation, there would be no legally valid decision, and so that question would be one that the tribunal could look at, because there was never any decision that triggered the presumption of regularity. But I appreciate that whether this is going to make much difference in the fast run of cases, it is speculative to some extent, but that is the sort of issue that the tribunal will be able to look at. So if we go back to section 103 on page 38, just to finish off the sort of quick review of the structure of this section, sub 2A deals with another species, if you like, of appeal in respect of decisions under section 4, and it says what it says. There's no issue in these cases about an appeal under section 2A, but the collateral challenge issue is as relevant to a section 2A appeal as it is to subsection 1 and 2 appeals.
Sorry, say it again.
So issue 1, it would be as relevant to a subsection 2A appeal in principle as it is to a subsection 1 and 2 appeal.
And that's because 2A follows the structure, although it elides it into one sentence of 1 and 2.
Yes. So the logic of our collateral challenge argument would be relevant to 2A, but of course a 2A appeal deals with section 4, which raises separate issues.
But we don't have to decide.
And you don't need to get into it. So I've got enough on my plate, I think, my lords, without getting into section 2A.
Yep.
Sub 3 sets out what the tribunal can do in response to an appeal. And in my submission, sub 3 is quite important because it indicates the scope of the tribunal's jurisdiction. A, require the Secretary of State to reconsider the matter. B, substitute its decision for the decision appealed against, or C, dismiss the appeal. Now, the matter in A, we say, looking at this in context, has to be the decision under appeal, or perhaps the basis of the decision under appeal, but there's no indication that the matter is so broad that it would cover a separate decision that has the effect
It's
of...
neutral, isn't it?
I'm sorry, my lord?
I'm sorry, I'm trying to restrain myself. It's neutral, isn't it?
Yeah, I mean, yeah, yes.
Take you anyway, one way or the other.
I think that's right, but it certainly doesn't point against my arguments.
Isn't the matter referring back to 1031, for example,
Yes,
or 1032?
yes,
It's the decision to do A or B.
thank you, Lord. That's our submission. And obviously B refers specifically to the decision appealed against. So, what we submit is looking at and this is the first point that we make in support of our arguments in respect of collateral challenge. What we submit is that looking at the text of section 103, it is clear that the focus is on a appeal from a particular decision, and in the ordinary way, the scope of the appeal would be limited to looking at the merits of that particular decision and no more broadly. And in support of that point, we've cited a case called Michalak and the GMC, which is at Authorities tab 24, I think volume 2, for those using hard copies, page 484.
Paragraph 22.
It's paragraph 20, in fact, my lord, on page 490. So that should be in your second volume of Authorities, tab 24, paragraph 20, page 490. And we've set this out in the written argument, the relevant passage. In its conventional connotation and, quote, appeal, if it's not qualified by any words of restriction, is a procedure which entails a review of an original decision in all its aspects. Thus, an appeal body or court may examine the basis on which the original decision was made, assess the merits of the conclusions of the body or court from which the appeal was taken, and if it disagrees with those conclusions, substitute its own. So that's the ordinary meaning or conventional connotation of an appeal. We submit that...
So sorry to interrupt, Mr. Biggs. Can I ask Miss Blackshaw to help me out again? Can you do that? Yes, sorry.
Not at all, my lord. So we submit that conventional meaning or conventional connotation of an appeal is consistent with the Secretary of State submissions, but not with the judgment below or the submissions of MAH. what the statutory scheme does in respect of a Section 103 appeal is allow for an appeal of a particular decision in all its aspects. But it is not an aspect of a decision under appeal that a prior decision has been taken which explains the decision under appeal, because that is a prior decision.
Sorry, I don't understand that. Surely the decision under appeal is the decision to withdraw asylum support,
Indeed.
to cease providing asylum support.
I'm sorry, the decision under appeal in a 103.1 appeal is the decision to refuse an application for Section 95 support, or
Yeah.
under 2 appeal, discontinuation of that support, yes.
I don't see why it's collateral to say, on the one hand, you don't qualify, and in the second case, you no longer qualify, or you are to be treated as having withdrawn your application.
The reason it's collateral, in my respectful submission, is my lord, this. That the reason you don't qualify, or the reason the support had to end, is because of a separate decision that could have predated the decision in question by conceivably a very long time, which is taken under a separate statutory scheme, the Immigration Act 1971, by the Secretary of State, pursuant to her authority under that scheme. So that's a separate decision that is not appealable.
Why is it separate? And suppose the ground were, we've looked into it and we think you're only 17 years old. And the appellant wants to say, I'm not under 18, here are my identity documents. Is that within the scope of the tribunal or not?
Insofar as the age would be relevant to eligibility or some other basis for the decision, that would be a matter that the tribunal would be able to look at.
Or you're not eligible because you have never made a claim for asylum.
That again, if there was an issue about that, then the tribunal would be able to resolve that issue.
But not, you are to be treated as having withdrawn your application because you didn't show up for an interview.
Well, if the first time that point was taken was in the decision that is appealed, I would accept that would be an aspect of the decision, but that's not the nature of the issue in this case. What do I mean by that? In these cases, separate decisions were taken, deeming the asylum claims to be withdrawn. Those decisions were not challenged, and so the submission is those are separate decisions to the decision appealed against, and pursuant to the conventional connotation of an appeal set out in MAH, what a tribunal can do is look at all aspects of a particular decision that confers a right of appeal, but not necessarily, but that doesn't cover a separate decision, even if that decision explains the decision under appeal.
No, it doesn't just explain, it's integral. Because it doesn't matter what language you use, it's inextricably bound up in the decision to withdraw support.
Well, our submission is that there is no review or reassertion of the withdrawal decision in the decisions under appeal in this case. The decisions under appeal in this case are predicated on the binding effect of an earlier historical decision treating the asylum claims as withdrawn.
It seems, looking at the plain words of 103.1,
Yes.
the complaint that is brought to the AST is about a decision that I, the asylum seeker, do not qualify.
Yes.
What warrant is there for breaking that down into first decisions, second decisions, and so forth? That my claim to the tribunal is that's wrong.
Well, it may be, my lords, that obviously I've got a lot of persuading to do.
But I mean, I know I'm not trying to persuade you of anything,
No, I
Mr.
know
Biggs.
that.
What I'm trying to do is to work out whether I'm missing something.
No, of course.
Because the wording of the actual statute is It's global. Does he or does he not qualify? Decision doesn't qualify. Appeal, I do. So why would one want to deprive the tribunal of the opportunity to reach the most convenient, swift, and holistic view of this by saying the tribunal can only decide part of the qualification, but the rest has got to go to another higher court, which most asylum seekers have no hope of getting anywhere near?
Well, at this point, at this stage of my argument, the simple point I'm making is that we're not dealing with an appeal from the withdrawal decision. And the withdrawal decision is not an aspect of, the merits of the withdrawal decision is not an aspect of the decision that is appealed.
That's your submission.
That's one part, that's one of, that's
You
one
say
point.
it should be hived off. It should be hived off. It's not part of. Don't matter, again, it don't matter what language you use. Your submission is it's not integral to. It's simply explanatory.
Yes, it's a separate decision. It explains the subsequent decision that is under appeal, but it's not a the merits of the withdrawal decision is not a component of the decision under appeal. That's the
So
submission.
if as just forgive me,
No, not at all.
if as a matter of fact, the Secretary of State, instead of doing it in 2 stabs, had done it in 1, had said, I have come to the view that your claim has been withdrawn, and simultaneously, because of that, I'm going to say you don't get any more support.
Well, in that situation, there might be a more difficult case for me to meet rhetorically, but conceptually our point would be the same. There are separate decisions.
Okay,
That
well,
would be a
may-
strange situation, but that
Maybe a way of stress testing your submission.
of course, it is with great respect, Lord, and it's of course an entirely helpful question. But that's my submission. So rhetorically, it would be more difficult for me, but as a matter of the conceptual analysis, it would remain the same because there would still be a decision taken under a separate statutory scheme, the Immigration Act 1971, to withdraw the asylum claim, and that would not be the appealable decision. The appealable decision would be the separate. And that's of course
Withdraw
not
the
what happened in these cases.
Withdraw the asylum claim
Yes.
as opposed to the claim for support.
Exactly. That's a different decision. So the decision that's appealed against is either in a sub 1 appeal, the decision to refuse an application for Section 95 support, or in a sub 2 appeal, the stoppage of support before that support would otherwise end. The reason why those decisions were taken is that there is a prior decision that means that the person is not eligible, but that prior decision is not appealable. That's the point I'm making at this stage. Can I move to another authority, unless there are any further questions at this point? It's perhaps less directly relevant, but it's perhaps helpful. It's the case of Begum number 1. I suspect the court's very familiar with it. That's at tab 21 of the hard copy, volume 2, page 569. And the relevant passages are paragraphs 68 to 69 on page 599.
Sorry, I'm a bit behind you.
So tab 20.
1 to tab 21.
28, my lord. Tab 28.
Thank you.
Begum, relevant passages 68 to 69, page 599.
Page number once more, please.
599, 599. 68, page 68 to 69. What the Supreme Court is explaining here is that generally, unless the statutory scheme under which an appeal is set up indicates otherwise, I'm sorry, I'll just let my lord.
Sorry, Mr. Bates.
Not at all, my lord. So what's being explained at paragraph 68 and 69 in Begum is that generally, so unless the statutory scheme indicates otherwise, provides correct construction, a court or tribunal on appeal cannot decide how a statutory discretion conferred on the primary decision maker ought to be exercised. Now, the reason that this is relevant in this case is that under the statutory scheme in this that's relevant here, it is the Secretary of State that has the relevant statutory discretion and authority. So again, what do I mean? I'm referring here to the general powers of immigration control under the Immigration Act 1971, an aspect of which is the power to control and make decisions about procedure, viz, in this case, the power to decide that an asylum claim has been withdrawn, or to deem an asylum claim withdrawn pursuant to paragraph 333C of the immigration rules. And so there would need to be something in section 103 that indicated, that showed that Parliament conferred jurisdiction on the AST to, if you like, and with great respect, interfere with the exercise of the Secretary of State's authority under the 1971 Act to make a decision deeming an asylum claim withdrawn. And my submission is there is nothing in the 1999 Act that goes that far, and Parliament cannot have intended to confer such a broad jurisdiction. The next point I want to make is in respect of the principle of regularity and its relevance to construction of section 103. So the submission is that the principle of regularity, which is the principle that a decision of a public body is binding and final unless it is challenged by way of judicial review or a court or tribunal of competent jurisdiction. That principle is a background principle against which Parliament legislated when enacting section 103. And so that background principle tends to inform the limits of the jurisdiction under section 103. The supplementary bundle is relevant to this point. We've included excerpts from Bennion, Bailey and Norbury on statutory interpretation. I won't, for the sake of my oral submissions, take you through those passages because I think they're uncontroversial and well known, but just to give you the references, it's paragraph 24.5, supplementary authorities page 118, and paragraph 25.1, page 126, and paragraph 25.3, page 131. What those passages show is that the principles of the common law and the legal framework more broadly forms the backdrop against which Parliament legislates and therefore indicates, informs the construction of a statute. That point is also supported by the observations of Lord Reed in the Black-Clawson case, which is in the supplementary authorities. It's the first item beginning on page 3, and the relevant passage is on page 26.
Supplementary authorities, page 3.
Beginning page 3, page 26 for the relevant passage should be line marked. 26B to E.
And 26 letters where?
B to E. It's just on line marked on the right, unhelpfully
Sorry,
cut
this is
off.
quite a well-known passage from
It
what
is.
I think was Lord Reed's last case. But what's it got to do with the present case?
Well, what it has to do with the present case, my lord, is this. The background against which Section 103 was enacted was a situation where under the relevant statutory scheme, decisions could be taken, which would have binding effect because of the principle of regularity. In particular, in this case, decisions to deem an asylum claim withdrawn. And so what Lord Reed is pointing out in this passage is that that common law principle is not to be taken to be abrogated unless there's some clear indication in the statute that that is intended. Now, this takes me only so far. I don't exaggerate the significance of this point or the points made in Bailey. The simple point I'm making here is that the principle of regularity is the background against which Section 103 was enacted. And bearing that in mind, and bearing in mind how the Immigration Act 1971 operates by conferring authority on the Secretary of State to make decisions as to whether an asylum claim is withdrawn, my submission is that Parliament must have legislated Section 103 on the basis that a decision to withdraw an asylum claim was not appealable and was not a matter that could be challenged. The merits of that decision, was not something that could be challenged in a Section 103 appeal.
When you say a decision to withdraw, you use that expression a number of times. It's to treat as withdrawn.
That's right, my lord.
Yes, it's just shorthand, isn't it?
It's shorthand because there are a number of possibilities. One is that there's if you like, voluntary withdrawal.
Yes.
Now, our submission, this is set out in our written submissions in response to the interveners' submissions, is that the same analysis under the statutory scheme applies, whether it's an explicit withdrawal by an asylum seeker, erstwhile asylum seeker, or a deemed withdrawal pursuant to the provisions of paragraph 333C. There has to be a specific decision by the Secretary of State under the statutory scheme treating the asylum claim as withdrawn. Otherwise, under the statutory scheme, there's still a claim. And that's why we get into this whole argument in my submission, because once you understand the statutory scheme in those terms, in my submission, that is the right way to understand the statutory scheme, it should become clear that the effect of a decision by the Secretary of State under the authority conferred by the Immigration Act 1971 to treat an asylum claim as withdrawn for whatever reason is that the person is no longer an asylum seeker. And so unless you have jurisdiction to get into the merits of that decision, you're not going to be eligible for support.
Why is the tribunal entitled to look at the merits of a decision by the Secretary of State that the applicant is not 18, but not otherwise?
Well, this was a point put to me earlier, so it may be that I wasn't entirely clear. If the basis for a decision that is appealable, so refusal of a Section 95 application or discontinuation, is the person's age, and I'm not frankly sure why that would be the basis for such a decision, then that would set up a factual issue which the tribunal would be able to itself consider, because that would be an aspect of the decision under appeal.
Okay, you're right at the nub of what I don't understand.
Right. Well, I'll have another go at just trying to crystallise it.
I'm not trying to make it difficult for you. I just said you understand my difficulty.
Yes.
I don't understand the conceptual difference between looking at the merits of a finding by the Secretary of State that the person's not destitute or the person's not 18,
yeah, and
that a person hasn't attended for his interview.
Well,
I just don't get it.
And with great respect, I don't blame you, because there isn't any material difference.
That's encouraging.
Where the material difference comes in, my lord, is that there is, and what the key issue in this case is about, is that where there is a decision to deem an asylum claim withdrawn, that decision has legal consequences. And that decision, because it's not the decision that's appealable, cannot be reopened, set aside, gone behind by the First-tier Tribunal in a Section 103 appeal.
Does it work like this? That you're not seen to argue with the interpretation of 1031, let's take one for the moment, which is to do with a decision that somebody's qualified.
Yes.
That on its face, that would appear to allow the tribunal to investigate all the elements of qualification.
Yes.
But your argument, as I understand it, is that because Parliament has not provided a route of appeal in relation to the withdrawal determination, therefore the statute should be in the later, so the part of the statute with which we're concerned should be narrowly construed in order to eliminate, in effect, the provision of an appeal by other means. But because, or the provision of support to somebody who has been found not to be in possession of an active claim. Is that how it works?
Broadly right, Lord.
You're not so much disagreeing with the interpretation of the wording of the principal section,
yes.
but you're asking us to draw inferences from the fact that Parliament did not provide an appeal route against the Secretary of State's decision, good, bad, or indifferent, that a claim was treated as withdrawn.
Yes.
Is that the main framework of your argument?
Essentially, yes. It's not, though, that we seek to persuade the court to adopt a narrow construction of Section 103, because I think that does load the issue rather with great respect. We submit simply that properly interpreted Section 103 does not extend to, confer a jurisdiction that extends to allowing a tribunal to investigate the merits of a decision by the Secretary of State under the 71 Act to treat an asylum claim as withdrawn, because that would interfere with the authority conferred on the Secretary of State by Parliament by the 71 Act. And there's no warrant, looking at the language of Section 103, its purpose and its context, bearing in mind the point I've made about the background against which Section 103 was legislated and the observations that I've drawn attention to in Begum and Mishlak about the nature and scope of a statutory appeal.
Why doesn't that apply to destitution?
Because destitution is a question that goes directly to eligibility. It will be a matter that the decision maker forms a view about in the decision under appeal. What the decision maker in the decision under appeal is not doing is looking at whether an asylum claim is being withdrawn, or is not taking a decision to deem an asylum claim as withdrawn. They may be looking back and asking whether in the past there is such a decision, but they're not themselves deciding whether the asylum claim should be treated as withdrawn. That's the key point.
Have I completely misunderstood? If you had an asylum seeker who's getting support, and it came to the attention of the Secretary of State that they were not destitute, or there was a view that they were not destitute,
Yes.
then the Secretary of State would stop the support. You'd be under 103(2). But are you saying that in those circumstances, the tribunal cannot investigate whether or not he's destitute?
No, of course we don't make that point with respect, my lord. No, that would be a paradigm issue, if you like, that would be a paradigm issue, if that makes sense, for the first-tier tribunal to consider in a Section 103 to appeal, because it's an aspect. It's an aspect of the decision. It's something that the decision maker, in respect of the decision under appeal, has themselves decided. In these cases, what's happened is something quite different. The decision maker is not themselves deciding whether to deem an asylum claim withdrawn. They're simply notifying the recipient of decisions that might be appealable under Section 103(1) or 103(2) that an earlier decision has been taken, which is not an issue, which means that they're not eligible. That's the key distinction.
Okay. I'm going to try one last time.
All right.
So let's assume that this person is getting support, and the Secretary of State comes to the Secretary of State's attention that there's information to suggest that he's not destitute.
Yes.
Secretary of State takes a decision that he's not destitute.
Yes.
2 weeks later, the Secretary of State withdraws support because he's not destitute.
Yes.
What's the difference?
I see the, forgive me, I see the point, my lord. In the Secretary of State would not make a decision in that way, because the only way under the statutory scheme that a legally effective decision would be taken in that case is if the assessment of whether there was continuing destitution was made in the context of a discontinuation decision. In the context of a discontinuation decision. In other words, as that's the only reason that the decision maker would look at it. They wouldn't just be looking in the abstract at whether the person is no longer destitute. They'd be looking at whether the person is destitute or not as the basis for assessing whether to discontinue support or not. However, there may be reasons why a person's asylum claim is withdrawn that have absolutely nothing to do with Section 95 support. It very frequently happens that asylum claims are withdrawn even where the person is not seeking Section 95 support or isn't in receipt of it. So in that hypothetical, my lord, that you put to me, the reality is that the actual assessment of whether there's destitution or continuing destitution would be an aspect of the decision to discontinue that would be appealable. That is not the case in respect of the decisions that are appealed in this in these cases, with reference to the historical withdrawals of asylum claims. Because under the statutory scheme, the 71 Act, there's a need for decision makers to decide whether to withdraw an asylum claim quite independently of the question of Section 95 support. Because the withdrawal of an asylum claim obviously means that the merits of the claim will not need to be assessed. So that has a separate and distinct function under the statutory scheme that is a function that Parliament has conferred authority on the Secretary of State to exercise by the 71 Act.
Can I see if my note is correct? Because I'm going to come back to this after today and I need to be sure that I've got something down. If the basis of the decision is not 18, the tribunal can look at it. But the decision to deem an application withdrawn has legal consequences that cannot be gone behind.
Yes.
In answer to my question, what is the difference? You say that the decision about destitution would be an aspect of the decision to withdraw support and can therefore be looked at by the tribunal.
Yes, in the context of a Section 103(2) appeal, or in the Section 103(1), it would be an aspect of the decision to refuse an application for Section 95 support. Yeah.
So it can be looked at either under Section 103(1) or 2.
Yes.
Could you, at some point, for my benefit, just tell us where this provision, which falls within Part 6 of the 1999 Act, sits within the general landscape in relation to decisions about applications for asylum and remedies that are available at various points in relation to decisions that are challenged.
Thank you.
This may not be a convenient moment, but at some point, what would particularly help me in a sense would be your postcard about that, rather than an extensive.
I'll try and give you a postcard now, and if I fail, then I'll try. So the 1999 Act, as far as the relevant aspect of it that we're concerned with is about providing support for asylum seekers.
And are appeals against decisions relating to asylum, do they fall within Part 4?
No. They are covered by Part 5 of the Nationality, Immigration and Asylum Act 2002.
Just a moment. Part 5.
Yes, of the 2002 Nationality, Immigration and Asylum Act.
So is that claiming asylum and also appealing against asylum claim decisions?
Those are rights of appeal from refusals of asylum claims.
Part 5.
That's right. Part 5. Also human rights claims. we have part 5, the relevant parts of part 5 at page 50 and following behind tab 4.
Thank you.
In respect of decision making by the Secretary of State on asylum claims, so not rights of appeal, that's covered by the Immigration Act 1971. The key provisions in that respect are behind tab 1, page 5 and following. So the nub of it is that the Secretary of State has a broad discretion under the 1971 Act to grant leave to remain, informed by immigration rules made under section 3.2 of the 1971 Act. And the immigration rules regulate things like procedure as well as the substantive merits of an asylum claim. The key procedural rule for our purposes is paragraph 333C. Which we have behind tab 13. On page 97. And so this is why, throughout the course of my submissions, I've been referring to the 1971 Act and the authority conferred by Parliament under that Act.
In this process, you've pointed out to us that the lack of an appeal right from a treat as withdrawn decision.
Yes.
There is a lack of an appeal right there. Are there any other matters that are on not niche matters, but in a sense main road matters at which an asylum seeker would encounter a no appeal situation?
Forgive me, the most obvious and perhaps most relevant is paragraph 353 fresh claim decisions, which I'll come to. Paragraph 353 of the immigration rules.
Right, and just by all means take us through it now, but in general, what does that deal with?
So that deals with fresh claims, which I'll come to. I don't think we have that rule in the bundle, but we've got the relevant authorities.
It's rather familiar.
I had expected it to be. Which
outside
is
the context of asylum support as well.
And as I've already indicated, the legal position in respect of a fresh claim, paragraph 353 decision is no right of appeal because it's the Secretary of State's entitlement under the statutory scheme to decide whether there's a fresh claim or not. And that's even though, under the current iteration of Part 5 of the 2002 Act that I referred my Lord to, there is a right of appeal from the refusal of a protection claim, i.e. an asylum claim, or a human rights claim. And what's in issue in respect of a 353 fresh claim consideration is whether there is in fact such a claim.
Thank you very much.
So can I move on then and deal now with the purpose of section 103? The relevance of purpose to the statutory interpretation is of course well known, but I'll just give my lords a reference if that may help. We've included a case called PACCAR, decision of the Supreme Court, that brings together some relevant principles of interpretation. And I just refer my lords to paragraphs 40 to 42 on page 659 behind tab 30, page 659 behind tab 30, volume 2. And this just makes the point with respect that purpose is always important when interpreting a statute. The purpose those passages also acknowledge that explanatory notes are relevant when interpreting a statute, and in my submission they're relevant because they shed light on purpose. We have the relevant explanatory note in our authorities bundle. It's behind tab 3, page 49. towards the bottom of page 49. This is volume 1, tab 3, end of tab 3, page 49. Right at the bottom of the page, it's paragraph 317. And I just invite my lords to read that passage. This informs the purpose of section 103. The purpose is to provide, and is according to this note, to provide rights of appeal in respect of particular decisions and matters. No other matters may at present be considered by the ASA, now the First-tier Tribunal. So Parliament was quite clear, it seems, looking at this admissible aid for interpretation, that the right of appeal in respect of section 103, or the rights of appeal under that section, was limited.
Yes, but limited to refusal of support and termination of support.
Yes, to those
So
decisions.
your argument is circular. I haven't, I confess, got to the bottom of the paragraph, but if you're just concerned with the top of the paragraph,
Yeah.
then those are the matters that it's limited to.
Yes, well, you have my submission, whether, of course, it's accepted is another matter, but my submission is that a decision to withdraw an asylum claim under the 71 Act, Secretary of State's exercise of authority under that legislation, is a separate decision to a decision that's appealable. And so naturally, the appealable decision is not an aspect of the appealable decision. And so naturally, looking at the text of 317, if the scope of a Section 103 appeal is confined to appealable decisions and matters that go to that decision, aspects of that decision, to use Michelak at para 20, Lord Kerr's observations that we looked at earlier, then that would tend to exclude the interpretation of the courts and tribunal below and of MAH.
So another clue leading to the second last sentence of the paragraph is that the jurisdiction could be extended by regulations of a future date to include decisions on where support is to be provided.
Yes.
I mean, that has in fact happened.
No, that hasn't. That has
hasn't, in
not
fact.
happened.
That's okay. That's sub rule 7 or whatever it was.
Section
Yeah,
107.
subsection 7. That's right. 103.7.
37, yes.
So that's again an indicator that actually the scope of an appeal under Section 103 is fairly limited.
Again, it's neutral.
Well-
Well, if you're right about 103, 1 and 2, you don't need the explanatory notes, and if you're wrong, the explanatory notes simply repeat the same point.
I mean, I'm drawing attention to the explanatory notes because they are an aid to interpretation, because they inform the court as to purpose, and the purpose is focused on these specific decisions. I appreciate that's not an answer for the Secretary of State, but it is, in my submission, at least consistent with the Secretary of State submissions. The other authority that's relevant to purpose is the MAH case, or Melai. I may be mispronouncing it. If I am, forgive me.
Judge Gilbert.
Yes, I'm sorry. I just missed off the reference in my notes. It's tab 49, page 1086. Yes, and my lord's quite right. It's His Honour Judge Gilbert, sorry. The learned judge refers to the purpose of section 103 at paragraph 24 on page 1093.
Sidelined paragraph.
It's been sidelined, yes, my lord. Towards the latter part of para 94. Our submission is that purpose does not justify concluding that the tribunal has jurisdiction to investigate the merits of a separate decision. Can I turn now to deal with context?
Do you accept this case as rightly decided?
Yes. I mean, just yes. The answer is yes. Obviously, the law on the nature and scope of appeals has moved on a little bit. I have in mind Bagan number 1 in particular there, but we don't seek to go behind MAH. So context. Two broad points to make here. Firstly, there's nothing in the immediate and wider context of Section 103 within the Immigration and Asylum Act 1999 that indicates that it has that it confers a collateral challenge jurisdiction that extends to decisions under the 71 Act to deem an asylum claim withdrawn. The second point is that looking at the wider statutory scheme, and this is a point that I think my Lord Justice Jackson was perhaps foreshadowing. Looking at the wider statutory scheme, it would be surprising if Parliament intended to confer jurisdiction on the First-tier Tribunal to investigate the merits, let alone the legality, or legality, let alone the merits, I should say, of a decision deeming an asylum claim withdrawn under the 71 Act. And that's because under the wider statutory scheme, there are specific rights of appeal conferred for particular decisions, particular immigration decisions in particular. We looked already at the wider statutory scheme, Part 5 of the Nationality, Immigration and Asylum Act 2002, behind tab 4 of the Authorities, Volume 1, page 50 and following. There are specific rights of appeal in respect of specific immigration decisions, decisions to refuse asylum claims, decisions to refuse human rights claims. It used to be the case that there were more extensive rights of appeal. We don't have the legislation in the bundle, but there won't be any controversy. The rights of appeal were reduced by the Immigration Act 2014 into the current form. And so the submission is that against the background of the wider statutory scheme, it would be surprising if Parliament intended to allow the First-tier Tribunal to look at the merit, the validity or the merits of a decision under the 71 Act that's quite separate from a decision that is appealable.
So Section 82,
Yes.
we don't fall within Section 82.
No.
So
The point is that Parliament has, under the wider scheme for immigration appeals and related appeals, like under Part 4 of the 99 Act, Section 103, has conferred specific targeted rights of appeal where it's considered appropriate to do that.
and the Section 103 uses different words.
Of course it does, but I'm making a point about context here rather than text.
Yeah.
And the point about context is if you put the text of Section 103 into the context of the wider statutory scheme, that tends to support the Secretary of State's construction, because the wider statutory scheme involves specific limited rights of appeal, which indeed limit the grounds of appeal that are available. So if we look on page 52, the grounds of appeal available in respect of the rights of appeal under Section 82 are limited.
Could we once again just go back to 103?
Of course.
And in this case, contemplate 103 sub 3.
Yes.
What do you envisage an order of the AST looking like? what might a typical order requiring reconsideration of the same say about what the same is? In what would an order under sub B, a substituted decision, what form might it take?
Well, it would say, let's say, for example, in respect of the section 103.2 appeal, it would say support is to be reinstated. So the discontinuation decision falls away and support is to be reinstated. So effectively, the tribunal makes its own decision on the merits in respect of that particular decision.
Well, that would sort of be quite the easy one. But let's suppose it transpired that it was a 103.1 appeal. What does the tribunal do in those circumstances? Get out a calculator and say the Secretary of State is to pay X pounds per week?
Right. If there was an issue about the sort of mathematics behind it, in principle, I suppose it could do that. It may, though. There may.
Or is there there's a tariff?
Exactly. I think that this is unlikely to be a practical problem because it's pretty well established what the numbers will be. But in principle, the tribunal could say something about that. I mean, looking at at B, in that context, the 103.1, what the tribunal could do is say the I'm deciding that the application was well founded. This person is eligible for Section 95 support, and the Secretary of State would then have to honour that decision and would have to then provide the support. Alternatively, the matter could be the tribunal could require the Secretary of State to reconsider the matter, which obviously would be less concrete. But there's nothing in that provision that suggests that it's open to the tribunal to say, Secretary of State, you have to look again at a withdrawal, a deemed withdrawal of an asylum claim.
That's circular too, because if you're sending it back because you're not happy with the decision that he hasn't attended the interview or something. If you send it back to the Secretary of State, you say reconsider. What you're actually asking them to reconsider, and this may be your point, is the underlying the basis for the headline decision.
Yes. So if because that's not a decision that you can reopen and consider yourself as the tribunal, because that's the prior decision under the 71 Act to withdraw the asylum claim or deem it withdrawal, then there's no point in sending it back to the Secretary of State because the tribunal can't interfere with that decision. So I don't accept there's circularity. Our interpretation of sub 3 is consistent with our analysis because it's clearly focused on, and we clarified this earlier, the decisions under appeal. The First-tier Tribunal can require the decision under appeal, the matter, to be reconsidered, fine, not the prior deemed withdrawal to be reconsidered, or could substitute its own decision. So, I mean, this is why at the beginning of the argument I indicated that it was important to sort of start from the right perspective and not make any assumptions. That's what I was trying to get at, because if you make assumptions as to how this all works, I think you do potentially end up in a situation of circularity. What the Secretary of State is seeking to do through my submissions is to explain that actually standing back, looking at this objectively, Parliament did not intend to confer such a broad jurisdiction by Section 103. That's what I'm trying to do.
I'm sorry to ask you another question, but you've answered this. I'm sure you might ought to have understood, but let's suppose a situation in which it's deemed withdrawal because he didn't turn up. And so he's deemed withdrawal decision, you say separate. He has video recording, date stamped and authenticated by an expert, that says he was in Universe House on the time and the moment of the interview.
Yes.
But he simply wasn't called into it. So let's take a ridiculous example that we said here as that. Now, what's the tribunal to do with that in considering its powers under 103?
Well, insofar as there was an earlier decision deeming the asylum claim withdrawn on that basis, the tribunal could not go behind it.
Right. So the tribunal has to just bite its tongue and say this is the address of the administrative court,
But
even though it's plain error, as my lord I think began the day with. That's the system.
because Parliament has not conferred a jurisdiction that would allow the tribunal to look at that, just as it's not conferred a jurisdiction in respect of 353 decisions. Now, it may be that that's undesirable, but that's a matter for Parliament.
Thank
We
you.
respect that. Two authorities I'd like to refer to on context, because they show how the wider statutory scheme is consistent with the Secretary of State's case. And the first is a case called Arsan, which is at tab 38, page 888. And the relevant passage is paragraph 119. I think this is the last volume.
Have you got a page reference there?
Yes, it should be 888 for the electronic.
888 is the start.
I'm sorry, yes, that's for the start. Page 1, paragraph 119 is 923.
923.
923.
Thank you.
Which you appeared not for the Secretary of State.
And at paragraph, so the issue in Arsan was whether a human rights appeal could constitute an adequate alternative remedy to proceedings for judicial review challenging a Section 10 removal decision. And my submission that's mentioned at paragraph 119 was that it can't, because the tribunal in such an appeal would not have jurisdiction to take away the effect of a Section 10 decision. The court accepted that submission, but it went on to say that in the context of a human rights appeal, the tribunal could look at the factual issues, and then in the light of factual findings, the Secretary of State may be under an obligation in the context of human rights issues to do something. Now, my submission is that what that means is that this court accepted that the legality or merits of a Section 10 removal decision is not something that could be challenged in an appeal under Section 82 of the 2002 Act, which we've looked at. And that's consistent with my submissions about Section 103. And of course, I'm still in the point about wider context here. I appreciate we're in a different statutory landscape, but this is part of the wider statutory scheme. The other case I refer to, which is even stronger authority for this argument, is a more recent decision called Batter, tab 41, page 966. Tab 41, so last volume, volume 3, page 966. The relevant passages are paragraphs 68 to 70 on page 988. Now, this, just to orient the court to these passages, this case was about, concerned an appeal under subordinate legislation that conferred rights of appeal in respect of the EUSS, the European settlement scheme that was brought in post-Brexit and is governed to a degree by the withdrawal agreement, a piece of international law. So it's a statutory appeal jurisdiction which was concerned with, or is concerned with, whether a person is entitled under the withdrawal agreement or under the immigration rules that seek to give effect to it, to a new immigration status. And in that context, it was argued on behalf of the Secretary of State that it was open to the tribunal to go behind what was said to be an erroneous and a legally erroneous decision that facilitated the entry and residence of an appellant. And that argument was rejected at paragraph 68 to 70, in particular at paragraph 70, essentially for the same reasons that we put forward in support of issue 1 before my lords. Under the relevant statutory scheme, this court held, it was not open to the tribunal to go behind a separate and authoritative decision that was not the subject of an appeal.
Well, certainly not at the instance of the Secretary of State.
Well, I take that context on board, but the point must apply both ways, my lord.
Well,
No, I mean,
you say that as though it's obvious, but why is it obvious?
well, the legal...
Well, of course the Secretary of State couldn't go behind the decision of her or his own immigration officers.
Well, the argument wasn't based on an estoppel or legitimate expectation or something along those lines, and I certainly appreciate the point my Lord Lord Justice has been putting to me. But the principle that this court was setting out at 68 to 70 is the principle of regularity, and the question as to whether there's a collateral challenge jurisdiction. That legal principle cannot depend. That turns on the correct construction of the statutory scheme. It cannot depend on who the litigant making a particular argument is. So, we say, looking at the wider statutory context and the authorities relevant there, it would be surprising if Section 103 conferred the collateral challenge jurisdiction that the tribunal and court below held exists.
As a matter of construction, people on both sides are saying it would be surprising. But we simply have to construe the statute.
Yes. So
I mean, if it says what they say, you may be surprised. If it says what you say, they may be surprised. But is it of any help to say it would be surprising? I understand the submissions you've been making for the last 5 minutes very clearly about context and things like that.
thank you. Yeah.
Does saying surprising help?
It's perhaps not a very helpful way of putting the point. All I'm trying to point out is that the wider context supports the Secretary of State's interpretation. So we didn't go to PCCAR and the well-established principles in terms of statutory interpretation, but as I see it, there's a sort of hierarchy. You look at text, which we've done. You then look at potentially background principles, which we've done. That's perhaps not the right place in the hierarchy to look at it, but that's what we've done. You then look at context. You then look at purpose. You then look at context. At the moment, I'm on context. So this is an interpretative indicator that we respectfully submit tends to support the Secretary of State's construction. That's why we refer to these cases in the wider
context of the steps you've taken.
Yes.
They do not support a conclusion for which the respondent.
That's my submission. Yeah. The context supports the Secretary of State's construction rather than MAH's and the court and tribunal below's construction. I put it in that using that unhelpful phrase, surprising. But the point I was simply trying to make is that looking at the wider statutory context, Parliament in that context has been quite clear in providing only limited rights of appeal that concern particular decisions and don't go as far as allowing for an analogous collateral challenge jurisdiction to that which was held below to arise in respect of Section 103. We say that's a contextual indicator that strongly supports the Secretary of State's argument. The next topic that I'd like to deal with, and again, it's if you like, an aspect of context, is the way that paragraph 353 cases are dealt with under the statutory scheme. We submit there's no principled reason why withdrawal decisions, if I can put it like that, should be treated differently than paragraph 353 fresh claim decisions, because both decisions are made by the Secretary of State pursuant to her statutory authority under the Immigration Act 1971, and both sets of decisions do not involve specific rights of appeal under the wider statutory scheme. The nature of a paragraph 353 decision was recently authoritatively restated and re-examined by the Supreme Court in Robinson, which is at tab 27, volume 2, page 538. And the key passage that I want to refer my lords to for the purposes of my oral argument, although there's a helpful analysis of what 353 is, its background and how it functions under the current statutory scheme, which the court may want to look at, is paragraph 64 right at the end on page 568. Not quite at the end, but 3 paragraphs on it, page 568.
64.
Paragraph 64, my lord, yes. It's line marked on the left. So the issue in Robinson was whether, under the statutory scheme that we've looked at in Part 5 of the 2002 Act, because a right of appeal arose post the Immigration Act 2014, the changes to the immigration, to the appeal regime brought in by that legislation, because under the current scheme for immigration appeals, a right of appeal arose from a decision to refuse a human rights or asylum claim, it was argued that the tribunal had jurisdiction to itself determine whether there was a fresh claim or not. But the Supreme Court rejected that argument on the basis, essentially, that under the statutory scheme, the Secretary of State had authority to decide whether there was a claim or not.
I think I understand where you've got to, and I'm sorry if I'm slow. You say that a decision to treat a claim as having been withdrawn because you didn't show up to an interview, you didn't respond to a letter, is a decision under the 1971 Act. There is no statutory right of appeal at all, there never was. And since that is in truth what the are complaining of, the consequential decision to withdraw support is similarly unappealable, safe for judicial review.
Well, absolutely, I'm very grateful, my lord. I accept all of that, save for this slight caveat in respect of that very last part. We're dealing here with collateral challenge, so there would in fact be rights of appeal, but given the issues in these cases, which turned on whether there was a collateral challenge jurisdiction, if you like, the appeal would be valueless. In this very specific case.
You say that Judge Story, principal judge of the AST, should have realised that the tribunal's jurisdiction is effectively, unless you're dealing with mistaken identity or that sort, or mistaken age, the tribunal's decision is confined to issues of destitution.
Or other issues that don't turn on this separate decision that is beyond the scope of the tribunal. I mean, there may be other.
When Lord Justice Peter Jackson asked you to suggest some, you were in some difficulties.
That's right. We may be able to come up with some other examples.
I'm not as familiar with the. I'm sorry to talk over you, but the 353 situation as you and my lord are, but the context for a decision about the scope of 103 is a very urgent decision in relation to people who, I mean, it's like a housing decision,
yes,
isn't it? It's somebody needs a roof over their head tonight, or somebody needs money to buy food that week. Is there a read across to 353 decisions and new claims and so forth? I mean, are they not rather different considerations that bear on each of these two situations?
If you'll forgive me, my lord, yes and no. Yes, obviously there are differences in the way that my lord has indicated. 353, sorry, support eligibility, if I can put it like that, raises a whole raft of urgent considerations that are not relevant to 353. But equally, a 353 decision can have very serious implications.
Well, I understand, but the point I was trying to draw out in my own mind was, and one is the AST that strikes me, never having been there, as being something of a crisis court, and I'm not sure that reads across particularly into some of the other areas with which the broad statutory picture is dealing. I appreciate that fresh claim or no fresh claim could have enormous consequences downstream for people's futures, but it's not talking about the very nitty-gritty things that AST is concerned with.
Well, I think if I may, there are 2 points I'd just like to make. However it's been worked out, the situation in the AST seems to be this, that although there is a requirement for quite rapid action, there are short time limits for appeals, decisions have to be made normally within quite short time frames. The position seems to be that support will be continued while an appeal is continuing. So you bring an appeal and then that sort of holds the ring, so to speak, until the outcome of the appeal. So it's not quite as...
Yes, but you could, I mean, if you were right and you got a decision from this court overturning the judges below, then you'd be perfectly within your rights to go straight to the AST and say, strike this out because it's no more than collateral challenge to our original decision. It's not to do with the things that you're concerned with. And so I don't think we can have much comfort, can we, from the thought that things would go on anyhow.
That of course is right. I mean, it goes back to the point about what the law requires and what the law should require that I made earlier, but I'd certainly take my law's point. The reason I submit that paragraph 353 is particularly informative to issue 1 is that looking at this from the perspective of the statutory scheme and conceptually, there is no conceptual difference of any significance between a paragraph 333C deemed withdrawal decision and a paragraph 353 fresh claim decision. I appreciate the practical implications between 353 decisions and...
You're drawing us to the conceptual similarity and somewhat accepting the practical difference.
Yes, I mean, yeah, absolutely. But you know, I say again, 353 decisions can be extremely important. I mean, what 353 is doing is looking at whether someone has a claim that needs to be considered, often in the context of removal. And of course, if that goes wrong, then a person might be removed and persecuted. So you're talking potentially about life and limb. So 353 is a very serious context as well. So we looked at Robinson. The other case that I wanted to, sorry, just before I move on, just want to be clear in answer to my Lord Justice Bean's observation. We do obviously say that in respect of a Section 103(2) appeal, as a consequence of a deemed withdrawal, the support under the statutory scheme would have to have ended irrespective of the discontinuation decision, and that does mean there's no right of appeal in respect of Section 103(2), and that's issue 2. But in respect of Section 103(1), there would be a right of appeal. It's just that you wouldn't be able to argue that the deemed withdrawal was wrong because of the limits of the tribunal's jurisdiction, because it doesn't extend to a collateral challenge. I just wanted to be clear about that. So the other case I want to refer to in respect of 353 is MG, a decision of the tribunal that was referred to by Mr. Justice Chamberlain below. It's at tab 49, page 1158.
Sorry, just say again.
MG is the name of the case. Tab 49, page 1158. Paragraph 2 of the head note sets out the conclusion. This is a judicial head note, so it's not. So it is actually part of the decision or reasoning. And paragraph 11 to 18, or on page 1160 to 1162 for the relevant reasoning. I don't invite my lords to read all of that now. The relevance of MG, as Mr. Justice Chamberlain explained, is that it acknowledges that there is no right of appeal from a 353 decision because the Secretary of State has authority to make those decisions.
Mhm.
And you've got my submission, I hope. Whether you accept it or not is another matter. But I say deemed withdrawal decisions are precisely analogous from a conceptual and statutory point of view. The final case on this topic is a case called Nigatu, tab 45, page 1079. This case concerned specifically the scope of the AST's jurisdiction in a Section 103 appeal in respect of paragraph 353 decision.
I'm just getting behind. 1079.
Yes, begins on 1079, tab 45.
Thanks so much.
So paragraph 1 on 10, perhaps I've given the wrong reference actually.
1077.
This is a decision of Mr. Justice Collins.
That's right, sorry.
Which starts on page 1076.
1076, not 1079, forgive me. But it's behind tab 45.
Thank you.
Paragraph 1 identifies the issue helpfully. So that issue, as summarised at para 1, is very close to the issue in respect of issue 1 before my lords. So this individual was saying, I'm entitled to support because I've made a fresh claim, and that means I satisfy the requirements in Section 94. I'm an asylum seeker for the purposes of Section 94.
Well, that depends on whether has made a claim which has been recorded but not determined.
Yes,
Could include second, third, fourth, fifth or 10th claims.
absolutely.
Answer no.
Right, but just to take some of the questions that have been put to me, hypothetical questions, just imagine a paragraph 353 decision that's erroneous on its face, completely ridiculous, outrageous decision that says you've not made a fresh claim, and it's absolutely obvious to anyone who wants to think about it that he has made a fresh claim. What Mr. Justice Collins explains, if we look at paragraph 21 to 26 on page 1081, is that it's just not open to the AST to itself investigate whether a 353 decision is valid or not, or is right or not, because under the statutory scheme, the 353 decision is a matter for the Secretary of State. See paragraph 21 and 22, particularly 21. The third sentence, I think, at 21. The Secretary of State is indeed entitled to consider whether the representatives made can properly be said to amount to a fresh claim. And then you get the conclusion at 26. Only that the fact that making a satisfied that making of what is asserted to be a fresh claim does not automatically trigger the right to continuing support. That only arises when the Secretary of State decides that it can be properly regarded as a fresh claim. Now, on the logic of the judgment below and my learned friend's arguments, this is wrong, because it should be open to the first-tier tribunal in a Section 103 appeal to go behind the 353 decision. There's simply no logical or principled basis for taking a different approach in respect of deemed withdrawals. Deemed withdrawals are taken pursuant to the broad discretionary power under the 71 Act and pursuant to a particular immigration rule, paragraph 333C. Similar, exactly the same conceptual analysis applies in respect of paragraph 353. In fact, if anything, there's a stronger argument that you should be able to go behind a 353 decision from a conceptual point of view, because because you can argue that it's really a hard-edged matter as to whether or not you've made a protection claim or not, given that protection status is declaratory.
It's a hard-edged matter as to whether you did or didn't turn up for an interview.
Indeed it is.
Discretion.
It's hard-edged.
So it's either you did or you didn't.
It can be hard-edged, but my lord, there may be nuance. It calls often for an evaluative judgment. Let's just imagine hypothetically that you've been given a number of opportunities to attend. On the first opportunity, you come up with an excuse which is accepted. On the second opportunity, you come up with an excuse that's not accepted. That's not a hard-edged question. That's an evaluative judgment which, under the statutory scheme, is for the Secretary of State. So, the final point that I want to make, the penultimate point I want to make in respect of issue 1 is that the Secretary of State's construction of Section 103 is the most coherent and principled. It may lead to results that are considered by some to be undesirable, but that's a matter for Parliament. You already have the point that I've made about 353. There's a further point about how this all works in respect of decisions on asylum claims, because on the analysis of the administrative court below and the tribunal below, there's no principled reason, save for the possibility of a special bar because of a right of appeal. With that caveat, there's no principled reason why a determination of an asylum claim on the merits would not be something that the Asylum Support Tribunal could investigate.
Can you say that once more?
So, with the caveat that there's a potential bar because of a statutory appeal from such a decision, on the analysis of the court and tribunal below, there's no principled reason why a decision by the Secretary of State as to the merits of an asylum claim, which would constitute the determination of the asylum claim, could not be, if you like, reopened and reconsidered by the tribunal. The only reason that that can't be done as a matter of conceptual analysis in my submission is because that's a matter that is not separately appealable to the First-tier Tribunal under Section 103, and is a matter that is for the Secretary of State under the wider statutory scheme, the 1971 Act. Now, what Mr. Justice Chamberlain held in respect of that point, or at least implicitly suggested in respect of that point, is that there was some special reason under the statutory scheme that would preclude the First-tier Tribunal looking at the merits of a decision on an asylum claim, because under the wider statutory scheme, there is in fact a right of appeal to another tribunal. But in my submission, that's not an adequate answer to the point, because of the conceptual possibility that that right of appeal might be taken away. Just imagine a hypothetical world where the right of appeal was taken away. Would that somehow mean that it would be open to the First-tier Tribunal to itself consider the merits of the Secretary of State's assessment of an asylum claim? Well, it would then appear to be the case that it would be. But that can't be right.
Forgive me, my lords may have followed that submission, but I got lost about halfway through it. Could you either refine it or at least explain it again? I'm not with you.
Yeah.
I don't understand.
So on the logic of the judges of Mr. Justice Chamberlain's analysis, as I understand it, it doesn't matter whether a decision that explains the decision under appeal is a separate decision taken under a specific statutory power, because it's relevant to the question of eligibility under Section 94 and 95. The First-tier Tribunal can itself consider the merits of that decision.
Why would it? There's nothing in section 94 or 95, which says that the asylum claim must be valid or meritorious or anything like that.
Forgive me, my lord. That's exactly what it well, it doesn't quite say that, but it does. But if we go to section 94 on page 25 behind tab 3. What a decision on the asylum claim goes to is whether the claim is determined or not.
Yes.
So
It doesn't matter whether it's a good one or a bad one.
I agree. But if the Secretary of State decides the asylum claim, and there's no right of appeal in this hypothetical example,
Is this section 21?
section 94, definition of asylum seeker at the top of page 25.
It's just I've landed in the middle of the asylum support regulations, which are thoroughly scrambled
Right.
in the electronic version.
Yes.
So could you give me the page again?
Yes, it's page 25.
Thank you so much.
I'm sorry if there are problems with the electronic bundle. We can try and fix those if we need
It'll
to.
persuade me not to read them.
We certainly don't want you to. We don't refer you to them, my lord. So if you look at the end of the definition of asylum seeker, right at the top of page 25, you'll see the words "which has not been determined." Now, what Mr. Justice Chamberlain held at paragraph 90 below, in his judgment below, is that where you have a withdrawal, deemed withdrawal, that effectively means that a person is not an asylum seeker. He got to that conclusion by reading words in, and we don't take issue with that analysis. The important thing is that there's no longer an asylum claim that could satisfy the definition of asylum seeker because of a deemed withdrawal. And there's no issue between the parties about that aspect of Mr. Justice Chamberlain's judgment. But the same logic would apply in respect of a decision on the merits of an asylum claim. So the Secretary of State makes a decision to refuse an asylum claim. In the hypothetical world that I'm postulating, there's no right of appeal from that decision. On Mr. Justice Chamberlain's analysis, it would be open to the First-tier Tribunal in an appeal under Section 103 to itself decide the merits of the asylum claim. And that cannot be right. That's my submission. But that's the logic of the analysis of the court below and the tribunal below. That's all.
No,
Because there's no appeal against the withdrawal.
Well, the only reason that Mr. Justice Chamberlain gave as to why a decision to refuse an asylum claim would not be something that the AST would be able to itself look at is that there's a special reason under the statutory scheme because there's a right of appeal. But we submit that's not an adequate reason because you can postulate a world where there isn't a right of appeal. And once you do that, you're left with the logic of Mr. Justice Chamberlain's analysis, which would entail that the FDT can look at the merits of an asylum claim. Parliament cannot have intended that.
So is it as simple as this? There is no appeal against a withdrawal decision as such.
Yes.
That being so, it's illogical to give the tribunal jurisdiction to look at the merits.
As a matter of principle, there's no principled reason to conclude that the tribunal, Section 103 appeal has a collateral challenge jurisdiction that extends to looking at decisions deeming an asylum claim withdrawn taken under the 71 Act. Because as a matter of logic and principle, there's no proper. This is the point I'm making at the moment. Anyway, there's no proper basis for distinguishing that situation from a 353 decision or indeed a decision on the merits of an asylum claim. That's the submission.
No, but I thought you were founding this point on the fact that there is no appeal provided against withdrawal decision.
Yes, I am. I'm simply trying to deal with the logic of Mr. Justice Chamberlain's analysis, which I say extends to decisions on the merits of an asylum claim. His answer to that is, well, it's paragraph 104 of the judgment below. Well, there is a right of appeal. But my submission is that actually because it's contingent, could be taken away by Parliament in the future. That can't inform the
You're
construction of
inviting
Section
us into a counterfactual world in which in which the Secretary of State had absolute discretion as to whether somebody was an asylum seeker or not. Anyhow, so we're invited to go into that world in order to...
Subject to judicial review.
Yes, so it's just to test the logic of Mr.
Yes.
Justice Chamberlain's. It's not the
Okay.
strongest point, it's not the only point I make, but it
Right.
does test the logic of Mr. Justice Chamberlain's analysis. That's my.
Mr. Biggs, I appreciate we've been bombarding you with questions.
Yes.
Very patient with us, but we still haven't got to the distinction between 1031 and 1032
No.
and the decision in Dogan. So can we turn to that now?
Yes, just one final point, if I may, on issue one, then we'll turn to that. The final point on issue one, just to be clear about this, is that the MAH case that we looked at earlier, which Mr. Justice Chamberlain places substantial reliance upon, and I think my lords may see force in Mr. Justice Chamberlain's analysis by reference to MAH, just doesn't assist because it didn't concern the collateral challenge issue. All MAH decided was that in a section 1031 appeal, the tribunal does have jurisdiction to look at eligibility, look at definitions in section 95(4) and other relevant matters. But there was no issue in that case about the scope of about collateral challenge. That's all I wanted to say. Actually, I should, before I move on to the second issue, just very briefly deal with my own friend's arguments against me, and perhaps I'll have to say, reserve my position on reply. But just to be fair to my learned friend, we say that none of the arguments that MAH rely upon support the construction below on a proper analysis. None of the authorities that my learned friend relies upon help, because they're all distinguishable, and indeed most of them deal with different situations. So just to rattle through these very quickly, the Winder case, Winder, tab 14, page 100, that was a case about whether...
Well, Mr. Biggs, I'm a bit worried about this. If you do go through them in anticipation, you'll be rattling through so fast that my old and tired brain won't take them in usefully. And speaking for myself, I'd rather that you covered issue 2,
Yes.
and then see where Miss Savage gets with her authorities.
Thank you,
She may be bombarded.
I will do that. I'll just make the very broad headline point that none of
Right.
the authorities help. They're all distinguishable. The closest authorities my learning friend has to refer to are Foster and the case of EN, tab 27, page 843. But both of those cases concern very different statutory language. They're both statutory appeals, but they concern very different statutory language. They concerned statutory language that referred to either erroneous in point of law, in the case of Foster, or otherwise not in accordance with law, in the case of EN. And we don't see, and they concern regulations, subordinate legislation, that was said to be ultra vires. And the point was, well, if a decision relies on ultra vires legislation, then the decision is erroneous in point of law. That was accepted by Mr. Beloff in Foster and accepted by the House of Lords in Foster. And that was the basis of the decision in EN, albeit by reference to slightly different statutory language. That just doesn't assist in my submission. So turning to issue 2, Dogan is the key case. Tab 36, forgive me, page 832. On page 833 and 834, there is a headnote, or holding aspect of the headnote. And we don't accept, actually, that what's set out at point 2 of the holding is obiter, because it formed an independent basis for Lord Justice Law's reasoning. But in any case, if we're wrong about that, it's highly persuasive and correct. So the key reasoning, just jumping into this, begins at paragraph 17 on page 840 and following. And at paragraph 17 and 18, what you see is Lord Justice Laws, with whom the other members of the court agreed, accepting that for the purposes of the proviso in section 103.2 that we looked at right at the beginning of my submissions, that would otherwise come to an end aspect, if you don't meet the definition of asylum seeker in section 94, then the support, then that proviso is engaged. Because you're not eligible for the support, so there's no power, if you like, to provide the support under the statutory scheme. The judge went further and held that that would also be the case, the proviso would also apply, if there was a condition imposed by section 95 sub 9 that had not been met. Because in that event, even if there was the exercise of discretion by the Secretary of State, in that event, the statutory scheme provides that the support has to end. And I've line marked the other passages from paragraph 17. It's 17 all the way to 23, but I won't go through the remaining passages. So the submission is that sets out the correct analysis of section 103.2. And so the effect of a decision deeming an asylum claim withdrawn is that the support under the statutory scheme has to end. So in other words, the effect of a decision deeming an asylum claim withdrawn is to trigger the proviso in section 103.2 so as to prevent a right of appeal arising.
What does that not exclude? What's left of the 103.2 jurisdiction?
Well, in a case where there's a prior decision withdrawing an asylum claim, there is no right of appeal.
Yeah.
But it's important to bear in mind the wider context. We're dealing with a very specific set of cases that concern a very specific situation where there's a prior decision deeming an asylum claim withdrawn.
I suppose that
in other cases there would be rights of appeal.
2 letters from the Home Office. Letter 1 says, we've looked into your alleged destitution and we think you're telling us a pack of lies.
Yes.
And the following letter is further to our earlier letter, we are withdrawing support.
Yeah, that would be appealable. Because the Secretary of State formed the view that you're no longer eligible for support because of destitution, but that's a judgment, and it doesn't mean that the support would have to end under the statutory scheme. What Lord Justice Laws has explained...
Because the decision would be that you're no longer an asylum seeker.
No, it would be a decision that you're not destitute. So what Lord Justice Laws is saying is that the proviso has to have some meaning, and what it means is that if you fall outside the eligibility criteria in 94, the Secretary of State has no power to do anything. I mean, the main examples of cases where there would be a right of appeal under section 103.2 are cases where regulation 20 of the Asylum Support Regulations 2000 apply. Now those are behind tab 11, page 87 and following, and regulation 20 is on page 88. And that sets out, following EU law, circumstances where support can be suspended or discontinued.
From a person who remains an asylum seeker.
Yeah. So and that's I think probably the mainstay of the work that the AST does in respect of section 103.2 appeals. You can actually see that implicitly from the way that Judge Story reasoned Judge Story referred to a right of appeal from a breach of condition under K, the top of page 89. But as my learned friend Ms. Savage points out, the condition referred to in that paragraph is actually a much more narrow type of condition than that which Lord Justice Laws was concerned with. It's a specific condition about location, looking at, I think it's regulation 19.3, or maybe 23, but there's no dispute about that. So there would be a lot for the tribunal to do if we're right, that Dogan is correctly decided, but we submit Dogan's reasoning is binding on you with respect. But in any event, the analysis is cogent and should be followed. So the logic is that a prior withdrawal decision means that the proviso is engaged, just as the interveners point out, ASAP point out, would be the case if there was a decision on the merits of an asylum claim subject to an appeal. They say, in their submissions, I think it's paragraph 8, that the proviso was focused on decisions discontinuing support, looking back at the definition of asylum seeker at the top of section 94 that we've looked at. But we say that the logic necessarily carries over to implied withdrawals, bearing in mind the conclusion of Mr. Justice Chamberlain at paragraph 50, which is that the withdrawal of an asylum claim is functionally equivalent to a decision to terminate the asylum claim. So, for example, a decision on the merits.
Well, it's functionally meaning it has the same.
Yeah, I mean,
as far as the asylum seeker is concerned,
they don't. Yeah, exactly. That's the point. I mean, you can say, well, actually, strictly conceptually, it means there's no decision, and that's what Judge Story says, and we accept that. But the reality is you won't get what you wanted, if I can put it like that. Now, we submit that there's nothing anomalous or problematic at all about this construction. It follows from the logic and reasoning in Dogan, but it's also consistent with our argument in respect of collateral challenge, issue 1. Because the decision of Mr. Justice Chamberlain below only works if the tribunal has jurisdiction to look behind a prior decision that means that your support will have come to an end under the statutory scheme, irrespective of the decision under appeal. So that's to put the cart before the horse, we say. And actually, if you so this, if anything, supports our argument in respect of issue 1. And is certainly a coherent interpretation of the scheme. We also point out, and this brings me back to paragraph 66 of my skeleton argument that I corrected earlier, that there's an incoherence with great respect in Mr. Justice Chamberlain's analysis. Because what it means, in effect, is that the tribunal would only have jurisdiction in a case that turns on whether a deemed withdrawal was valid or correct. The tribunal would only have jurisdiction to allow an appeal. Because
well, I didn't understand that when I read it.
All right. Because
I don't understand it now.
all right.
Because if you can have jurisdiction to dismiss an appeal. The appeal is brought.
Yeah, you certainly do.
The appeal is brought.
Yeah.
The premise is, if the appeal is good, the appeal is allowed. But if the appeal is bad, then you dismiss the appeal. You have jurisdiction to do that.
Yes, but I mean, on this analysis, that the tribunal would have, going back to a case called Carter and Arsan, the tribunal would have constitutive jurisdiction to look at whether it has jurisdiction, and so it would strictly have jurisdiction to get to that result. I accept that, but it's still anomalous in my submission. If we go to the text of paragraph 66 of my skeleton argument,
Hang on, constitutive jurisdiction.
Versus
I think that's gone straight into my book of horrible words.
It's not my. It's Lord Justice said.
Jurisdiction as a constitution to look at the issue.
Jurisdiction to look at the scope of its jurisdiction, and then jurisdiction to decide something within its jurisdiction. It's not my terminology, but
you don't get away with it that easily.
but my point is that this would still be anomalous if we look at paragraph 66 of my skeleton argument, because you've got to give the words "would otherwise have come to an end" some meaning. And what Mr. Justice Chamberlain is contending is that it's open to the tribunal to come to the conclusion that actually the support would have come to an end irrespective of the decision under challenge, because actually there was a previous decision withdrawing an asylum claim which is meritorious. He accepts that that means that the support would have to end under the statutory scheme. That's the logic of paragraph 90 of Mr. Justice Chamberlain's decision. And so what that means, we submit, is that something's gone wrong in the reasoning, because it would effectively denude, this is the real point, my lord, it would effectively denude the proviso in section 1032 of any effect, except in cases where there's a decision on an asylum claim. But even the interveners ASAP accept that the proviso is broader than decisions, that it's broader in scope than covering simply decisions on asylum claims. See paragraphs 7 and 8 of the interveners' written submissions. And that must be right, because looking at the clear text of section 103(2), it doesn't say that the support would otherwise come to an end because of a decision on the asylum claim. It's expressed in much broader language. And the logic of Mr. Justice Chamberlain's decision is that a deemed withdrawal of an asylum claim means that the support would come to the would have to come to an end under the statutory scheme, irrespective of the decision under appeal. And I say again, the correct analysis of the decisions appealed in this case is not that they constituted themselves decisions to deem asylum claims withdrawn, but rather that they simply declared to the support recipients that their support had to come to an end in the light of a prior binding decision that their asylum claims had been deemed withdrawn. My lords, I'm conscious of the time. Those I think are my submissions in respect of issues 1 and 2.
Thank you very much. I just had one question, if I may, before we break. I noted your submission a moment ago that Dogan is binding upon us and decides ground in the second issue in your favour.
Yeah.
One of the beauties of electronic working is that you can look to see what people have said about this sort of thing. My search in relation to Dogan and the emphasis that's been put on it led me mainly to the interveners' submissions, in which they rely on Dogan and explain why it doesn't deal with the situation we have here, because it's dealing with the condition. Have you previously, you previously submitted that Dogan was binding on the FTT?
Yes.
But did you make the submission to the High Court or previously to this court that Dogan was binding on us? Because in a sense, if that was true and that was your case, then we could have saved a lot of time by just looking in great detail at Dogan and finding that our efforts weren't required if it's binding upon us.
Well,
have you previously suggested that?
It only goes to issue 2, and yes, we have previously suggested that.
Yes, that it was binding on us.
Yes.
You did submit that.
We'll double check, but I'm pretty confident that that was our argument all along.
Yeah.
Just on the interveners' submissions on this, I mean, you've got the text of Dogan, paragraph 17 to 23, I think. It says what it says, and it clearly is. It supports the Secretary of State's analysis. But you've also got the holding that I referred you to in the head note, and the second paragraph of that holding seems inconsistent with what ASAP say. So, with respect, ASAP have misunderstood Dogan. We respectfully submit, unless I've misunderstood them, but then it doesn't matter.
All right.
Unless I can assist further.
Well, that leads me to say that I have now been supplied with the interveners' submissions, which I will read during the lunch hour. And unless you tell us at 2 o'clock that you had overlooked something, Mr. Biggs will pass the baton on to Ms. Savage.
Can I just very briefly just highlight, if my lords get any time over lunch, a helpful answer to the context of the ASD is contained in Mr. Richard Copeson's witness statement, which is in the bundle that you've just received, the supplementary bundle from the interveners. and also in the statement from Ellie Pachter, which is in the supplementary hearing bundle, tab 21, page 92.
Thank you.
Court rise in favour.